Ladies and gentlemen, gentlemen and ladies and gents, got a little bit of Anthony Davis. And, oh, I'm sorry. We're talking about a little bit of more than words. All right. Now that we've gotten that out of the way, my question is, what are we thinking about? Where have we been? Why haven't we been pushing this argument from day one? You guys have been going to court and you've been standing in court and you've been going to trial and all of this, and you've been going up against these attorneys, these lawyers. Interesting, ain't it? Let me ask you something. You have ever heard of this? Now, this is for California. Now, every state has its law with the unauthorized practice of law. Now, according to them, people like myself we can't write motions for people. I'm writing several motions right now. I practice law. And I let them know that I'm practicing law. But not the point, ladies and gentlemen. Not the point. Guess what the issue is? It's that there is a law in California with the unauthorized practice of law. Who gets to authorize the practice of law? Does anybody know? Does anybody know who authorizes the practice of law? You do. Now hold on. Unauthorized criminal penalties for unauthorized practice of law could be assessed in, for example, the following situations. Did you see how they put the word could be? Could be. That's swell, sir. Okay. Many of you have not heard of Sims versus Aaron's and Swear versus the Board of Examiners for the state of New Mexico. You know, I don't know which state Sims versus Aaron started in, but I do know it's a Supreme Court case, and I believe it is 1920. Let's do this. Let's look it up right now. This video is going to be short because I'm tired, want to go to sleep, ready to go to sleep, about to go to sleep. Okay. Uh-oh. I did not know it was 11 o'clock. Hold on. Past my bedtime. But I didn't want to go to sleep without bringing this to your attention. People are going to say, but we tried that and it didn't work. Because you didn't try it the right way. Okay, EEON'S. So we got Sims versus Aaron's, and see, it's got Sim versus Aaron's. Oh, okay, let's go to the Freedom School. It's actually got the cases there, so I'll live with that. Okay, court cases supporting no license needed to practice law. Okay. It should be bringing up cases like the NAACP. Let's see if they. I know Hines versus Karen. I know that case, but I'm looking to see if they got all the cases, because you know sometimes they. Oh, the Brotherhood of the Tradesmen. Yep, they got it in here. And Johnson versus Avery. Ladies and gentlemen, I'm gonna give Freedom School some credit because they put the right cases in. Now I just have to find the NAACP case. Who is this? Brian McKnight? How about some other time? All right. He understands. Give me a second. There it is. NAACP versus Button. So that means that they have all the cases here for the unauthorized practice of law. See, members of groups who are competent non-lawyers can assist other members of the group to achieve their goals and the goals of the group in court without being charged with the unauthorized practice of law. So you can represent other people in court. Hold on. Ladies and gentlemen, especially coming in as a next friend. If an infant or incompetent person does not have a duly appointed representative, he may sue by his next friend or by a guardian ad litem. Okay, so take yourselves to this. Just type in this in Google. Court cases supporting no license needed to practice law. Okay, that's just for you to have right now. Okay, let's get rid of you for right now. We'll come back to you in a minute. Let's go back to the unauthorized practice of law. The point we're getting at is, ladies and gentlemen, do you not know that they have this thing called the unauthorized practice of law? Well, you can't have the unauthorized practice of law. Impossible. Why? Because anyone can practice law. That's what was said in Sims versus Aarons. And I've read the whole case. It's not a long case. And if you've never read Sims versus Aarons, I would suggest you go and take a look at it. It's pretty straightforward. Now, the case Schwer versus the Board of Examiners. Schwer versus the Board of Examiners was more recent. I believe it was 1949 that case was had in the state of New Mexico, where they were doing that whole thing with going after people claiming that they were communists. And they decided to block this one guy from getting his license to practice law. In other words, his bar card. And he sued. And the Supreme Court kept in line with Sims versus Aarons. And pay attention, you're going to see Sims versus Aarons and Schwer versus the Board of Examiner in the same script from most people. Okay? Pay attention. The practice of law cannot be licensed by any state. Now, they don't do state upper and lower case. Now, that's one thing neither one Sims versus Aarons nor Schwer versus the Board of Examiners says. The practice of law retainer is a ripoff. The case doesn't say that either. Okay? I just want to let y'all know. I read both cases, and I know for a fact it don't say this, and I know it don't say this. It says no state may license the practice of law. Okay? It literally says that. Okay? So when you take a look at these cases, now these are the actual titles to the cases. So basically, like, let's say Schwer versus Board of Examiners, like I said, it's a New Mexico case. Very familiar with it. I should be familiar with it because I'm the one pointing it out to you people. So if I'm going to talk about it, I should be able to point it out. Now, again, as you guys have heard me say, there are a lot of people doing videos, and there are a lot of websites such as Freedom School where they'll put case law up there, but they won't tell you exactly what's going on with that case. So we're going to go to the case. See, there it is. This ain't it, but it's the California bar, and we don't really care about that. I think we're going to go to Justia, and then we're going to do a little search. So y'all want to search with me? Let's do this. We're going to do PRATICE of LAW, because we want no state may license the practice of law. Okay, so that's where we're going. And I don't know if it found it. I don't think it tried to find it. Hold on. That don't make no sense, because I know this is Schwer versus Board of Examiner. And so let's make sure I copy that. Nope, it's not letting me find it. And I did my search and everything. Let's go to find. No, not going to find it in Find Law. Find Law is going to be stupid. Dang it. What I'm saying, dang it, y'all heard me say dang it. The reason why I'm saying dang it is because dag nabbit, I know for, oh, wait a minute, it did it. Oh, it says no matches found. Oh, let's do this. I spelled practice wrong. That's why there's no matches found. Okay. On the record, this case, the state of New Mexico deprived petitioner of due process in denying him the opportunity to qualify for the practice of law. See, that's what this case is about. Okay? To qualify for the practice of law. See, what they did is they said that the states can qualify a person in the practice of law. Okay? Say, a state cannot exclude a person from the practice of law or from any other occupation in a manner or for a reason that contravenes due process of the Fifth Amendment. Okay, now, this is what I want you to understand. This is what the court said. Whether the practice of law is a right or a privilege need not be determined. Need not here be determined, because that's not the issue before the court. It is not a matter of state grace, and a person cannot be barred except for valid reason. No, anyone can practice law. The reason why they don't want to discuss whether or not it is a right or a privilege, because the moment they do that, they cannot hold you accountable for ignorance of law as no excuse. You see, once they make it into a privilege, telling somebody they can only do it under this circumstance or that circumstance, or if they have a license, then when they bring you to court and say, blah, 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 you go, blah, blah, blah. Okay, case dismissed. Why? Ladies and gentlemen, they'll have to dismiss the case because guess what? You didn't know the law. And in order for you to know the law, you have to have a license. I.e., this is why they cannot get any of you for the unauthorized practice of law. Okay? So that's why it says it's not a matter of state grace. Okay? Whether or not the practice of law is a right or a privilege need not here be determined. Now, why did they say that? Because they're quoting from Sims versus EEON'S. Okay, let's go here. Give me, this is still talking about swear. So I decided, oh, this is actually the case. This is actually the case. Interesting. There it is, swear, professional, blah, blah, blah. Don't need that. I need the practice of law. So let's get back to practice of law. Oh, okay. Oh, that's right. It's still, okay, I see what it did. I don't like that. I don't want practice of law being a right or privilege. Let's go to the next one. Give me 1 second. Uh-oh. I need to go back to the previous. I need the part of the case. No, that's not it. Give me a second. Haven't been here in a while. Like I said, I told you I read this because remember it's the Board of Examiners, so I already know it's the Board of Examiners. I know it's the state of New Mexico, and I know swears membership to the Communist Party. Like I said, that's what this case was all about. So that's why it had nothing to do with whether the practice of law is a right or not, a common right. Okay, but because of the way they said it, that's why you'll get people saying that it is a common right. The state cannot exclude a person from the practice of law or any other occupation. Not looking for that. And see, we need not enter into a discussion whether the practice of law is a right or a privilege, regardless of how the state grants of permission to engage in this occupation is characterized. It is sufficient to say that a person cannot be prevented from practicing except for valid reason. Certainly, the practice of law is not a matter of state grace. Okay, they've been saying this for years. The state cannot license the practice of law. It's not a thing where the state gets to say yes or no. And they'll never rule contrary. I guarantee you, I'm looking for that argument. I've had tons of judges tell me that they were going to hold me in contempt if I continued to help people. I make no lie to you, I'm not making this up. I'm not trying to make it seem like it was worse than it was. The one thing I told them to go back and tell him, I wrote the idiot and told him. Who was this? Goopy, whatever that idiot's name was. Okay, they called him Geppy, but Goopy, whatever his stupid name was. See, it has been well settled by the rules and practice of common law. See, they want to bring common law in when they feel like it. Courts, common law courts, that it rests exclusively with the courts to determine who is qualified to become one of its officers as an attorney or counselor, and for what cause he ought to be removed. See, they say it's up to the courts to determine who gets to be one of their officers. Ladies and gentlemen, there's no law saying the courts get to have officers. There's no law that says in order for you to speak in that court that you have to be one of the officers, because they can't do that. At that point, they're prohibiting you your right to counsel. So, ladies and gentlemen, why not hold them for practicing law without a license? Every single case, this is what they're doing. They're claiming now you notice how in California it's called the unauthorized practice of law, because they're saying somehow you can only practice law if you're authorized. Well, if the state can't license the practice of law, oh, I'm sorry, I apologize. Let me get rid of that word. I said the state can't license the practice of law. Sorry, I was wrong. It's not the fact that the state can't license the practice of law. I got to get back to, you know what? Let's do this. GRACE. Okay, pay attention. Does not hold it as a matter of grace or favor. Okay, here's the thing, ladies and gentlemen. The reason why it's not a matter of state grace, you know what grace is? Somebody giving you the approval. Somebody giving you the permission because you bowed down to them and said, okay, yes, sir, master. Okay, let's get to not looking for that one. I know it's in here more than twice. That don't make no sense. Okay, yeah, it's only showing up twice, but I know it's in here because I've seen it in here where it said it's not a matter of state grace. Okay, let's put the two words together. And it says not found. Let's do, ladies and gentlemen, this song has some very, very important meaning to me. It just, one of those songs that has just stuck with me. Oh, that's right, I'm looking, it's a different case that we're in right now. That's why I can't find it. We switched to a different case, so this is no longer swear. This is swear here. So when I look up not a matter, watch. Wait, I don't see you. Where you at? Not a matter? Okay. Not a matter of the state's grace. In other words, you ain't got to bow down to the state to get permission to do something, to practice law. That's why they say, and by the way, ladies and gentlemen, you need to understand, they have never determined whether the practice of law is a right or a privilege. They cannot, because ignorance of the law is no excuse. So since everyone is deemed to know the law, they cannot license it. It's a common right because everyone has the right to practice law. Do you understand? This is why they will never, ever, 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 ever come at me with some stupid thing talking about, oh, you're practicing law without a license. You're doing the unauthorized practice of law. Really? Is that what I'm doing? Okay, what's he doing? Where's his license? Where's his authorization? Can't get it from the bar. The bar is a private corporation, not the state. Doesn't represent the state. Private corporation can't represent the state. Do y'all really want to have this argument with me right now? The court's a private corporation, can't represent the state. So it can't receive authorization from a private corporation because if it received this authorization from a private corporation, I'm a private corporation. I gave myself authorization. If they can do it, I can do it. Equal protection of law. Sorry, that's my conversation with them. My conversation is tit for tat. People, age of 16, I joined a debating club. As a matter of fact, at that time, roughly around 1983, 1984, me and my friends, we would literally just sit and debate about everything and anything. Okay? That's all we would do. I've been prepared for the courts for a long time, which is why they never respond to any of my motions, because they can't. By the way, ladies and gentlemen, so that you guys get it, those of you who are dealing with the courts want, people do these things called memorandum of law and authorities, table of authorities. Ladies and gentlemen, do not use case law as your authorities and your table of authorities. Okay? You must understand, case law is not law. Authorities, their little case law, their little case statements, that's not law. This is not the law. This little phrase right here is just letting them know it's common knowledge among your stupid courts that you cannot license the practice of law, that the practice of law is a common right. They understand the terminology. Oh God, no, ladies and gentlemen, I don't like this group. I can't stand them. Okay, I can't stand that hizzy. that his own. Okay, and I don't care if she is married to that clown, that idiot. That I'm sorry, apologize for that, KZ. Ladies and gentlemen, what's been happening is we have not been attacking. We've been defending ourselves. Ladies and gentlemen, I'm saying you got an attorney, you got a prosecutor. It's not going to hurt you to charge them in court, even before the jury, saying, I object. The moment they stand up there and say, blah, 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 represented, I object. This person is not licensed to practice law. They don't have any standing here. The court's going to ask you to be quiet and all that. Nope, sorry. The rules say that the unauthorized practice of law is a felony. Equity cannot lend to a felony. The rules of equity cannot aid in a wrong. So if this is an equitable court, this person is here without the proper authorization. State law says they can't do it. They're licensed by blah, blah, blah. They have a blah, blah, blah. They're an officer of the... Sorry, the court's a private corporation. Sorry, California says the unauthorized practice of law, private corporations have no authority to authorize anything under the law. Only the state can do the authorization, and the state cannot grant such authority to a private corporation. Sorry, Constitution doesn't allow that. And if you have to go on appeal, that's your argument. They will come up with all they will never deal with the issue. They will make statements, it has been common knowledge and common blah, 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 that this is blah, blah, blah. So that's why you bring up the fact that the court is a private corporation. Look, of course they're going to ignore you. Of course they're going to ignore you. But you make sure they deal with the fact that the court is a private corporation. And as a private corporation, it doesn't have any authority to authorize anything. As a matter of fact, because you're a private corporation, you have no jurisdiction in this matter. So I need to challenge your jurisdiction. See, if you're allowing them to talk, then please understand that we'll have this discussion. You can't stop because now you just made it an issue in this case. Thank you. Many of you are trying to go into these courts. Many of you are trying to write these motions. Many of you are trying to open your mouths and you're trying to speak, and then you go in there and you get angry because you're paying attention to words. You're paying attention to what they're saying and their threats. Ladies and gentlemen, those threats that you hear them making, that's only to get a rise out of you. Once you let them know they got you, they got you. I got you, boo. Okay? You cannot let them win by gaining control over you. You cannot do that. So challenge their so-called practice of law. Challenge them for the unauthorized practice of law. Remember, the Constitution for every state says that the state government represents the people. Well, sorry, no private company is licensed to represent the people. No private company is authorized to represent the people. Go and check. Remember, anytime government engages in commercial business activity, they abandon their sovereign capacity to be treated as any other corporation, any ordinary corporation. People keep calling that the so-called Clearfield Doctrine. Ladies and gentlemen, that is not the Clearfield Doctrine. That doctrine has been around. That is a maxim. It's not a doctrine. Again, if you're going to listen to these individuals talk about the law, and there are a lot of them out there trying to explain to you guys what the law is and how to understand cases and how to read case law, and you are finding that many of them don't know. They're just parroting what they hear. So let me let you know, many of you, and this is the last thing we're going to talk about. We got New Edition talking about Stand in the Rain with Johnny Gill. This is the Johnny Gill New Edition. Can't really say that because Johnny Gill, he was just singing the lead and had the most powerful voice of the group at the time. But this was New Edition, people. And Johnny Gill was just added to the group at this time that this song came out. And we got them going to take us out at this point in time. Ladies and gentlemen, the purpose and the point of everything is many people are out there thinking that they understand the law. You have Minnesota Court Rule 220. Many people have misunderstood that. It has been said by those out there that I misunderstood the law. You see, the law, Minnesota Court Rule, let me show it to you. And then this, like I said, this song is going to take us on out. But let's do... turn on my keyboard. Let's see, 220. All right. Minnesota Court Rule 220, and it's usually going to be the first one that comes up. Okay, got to show you this because I want you all to understand that I know what this law is all about. I understand exactly what it's talking about, and I guarantee you it is talking about the registration of birth certificates, but it's also talking about the registration of titles, land title. Okay, hold on. Pay attention. The Register of Titles is authorized to receive for registration of memorials upon an outstanding certificate of title. Certificate of title refers to a land title, people, of an official birth certificate pertaining to the registered owner named in said certificate of title. However, guess what? We say land title, but that's not the definition. Go and look at the statute. That's the intent. Your birth certificate is land title. Let me help you out. Get the VPN, the parcel number for your particular hospital that's on your birth certificate. And then look at the number that's on your birth certificate, and you will see that that parcel number is included in the number for your birth certificate, i.e., your birth certificate is associated with that parcel number. It is title to land. I don't care what they say. They cannot disprove this because then they'd have to bring out the books and prove it. But we can tell you that man is land. They're made out of the same particles as we talked about in the video describing the universe. All of the compositions, all of the elements are in our bodies of this earth. Man was created from the earth, thus the composition of man is the earth. So man is land. They know that. That's why everything's associated with the Department of Agriculture. You are agriculture. Your birth certificate is an agricultural title, i.e. a land title. I understood Minnesota Court Rule 220. That's why it's captioned what it's captioned. Birth certificates. Why do you need a birth certificate? Why can't you just have a driver's license? Birth certificate doesn't have a photo on it. So why is a birth certificate for memorialization? Of course you can memorialize your birth certificate on the county record. Hold on. This is Johnny B. Johnny B, we're going to have to do you a different time. All right, let's get back to this so you guys can understand. Of course you can memorialize your birth certificate on the county record. Of course you can. Why? Because if you can do it with a land title, you can do it otherwise, which is why we are documenting our registration of our certificates so that everyone else will recognize that if Minnesota can have a law that says that once it's registered, the individuals to be treated as they've reached the age of majority and to be recognized as having attained the age of majority, we take care of that now. Okay? So, this is so you guys know. Many people were trying to say I didn't know what I was talking about, didn't know what I was saying, didn't know what I was doing when I started talking about this to people because other people had been on the bandwagon way before I jumped on it. I didn't know about Minnesota Court Rule 220 until 2014? Okay? But I read it. I understood what it was talking about. As I done told you, we already knew that there was a parcel number associated with the birth certificate. We already knew it was the one for the hospital. So when I read this, I understood it immediately. So this is just to let you folks know. If there was somebody else out there that was talking about law and that was explaining it to you in a way that I could positively say that man's right on the money, I will tell you that. But right now I've been listening and I've been hearing people and listening to some people do videos. I hear some people trying to bait you to come to their sites to spend money. Pay attention. You don't hear me doing that. I hear some people giving you partial information. Pay attention. You don't see me doing that anymore. Before, I just used to give you little nibbits. There you go. Snack on that for a while. All right, now shut up and leave it up. Okay, that was the way it used to be. But since I told you all, July of last year, I've been giving you guys the information. Not been holding back. Because we don't have time to be holding back information. Holding back the years. Anyway, we don't have that time, people. We do not have that type of time. It is simply not possible. It isn't possible, ladies and gentlemen. Look, they just went into Syria. They just bombed Syria. Doesn't that remind you people of something? Didn't they just do the same thing to Iraq and Libya? Didn't Clark, the general for the United States military, say that they were getting ready to bomb all of those eastern countries and Syria? Go back and listen to Wesley Clark talking about the so-called bombing of those Middle Eastern countries. That happened on NPR. Go back and listen. They're finishing out their plan. Oh God, and there's one other video I was watching and it talks about there's a doctor. And this doctor is talking about the chemtrails. But no, he's not talking about you have contrails and chemtrails. But they're actually showing the video of the planes releasing this into the air. And they call it micro aluminum. Microaluminum. Ladies and gentlemen, did we know that exists? Did you know what damage that does to the body? Did you know that it seeps into the skin? Seeps into the trees, the plants, the leaves, the grass, the animals, including organic food. That's why they're doing it. There's no such thing as organic anymore. Oh, well, we grow our food inside a greenhouse. Really? Well, didn't you know that these little micro aluminum particles seeps into the water supply? Oh, and when it combines with fluoride, I'm not the scientist. Ladies and gentlemen, I haven't done the microscopic research. But I tell you what, all of the scientists are beginning to speak up on this. Just do your research on what effect does aluminum have on the body? And then let's do the microparticles of aluminum. What effect will they have on the body? Do your own research. I told you they were poisoning us. I told you they were getting ready to step up this stuff. I told you, this is their game plan. Ladies and gentlemen, what I would suggest, there are things you can take to get rid of the heavy metals in your system. Okay, I'm not going to tell you what, because I don't take it. I trust the God that I serve. Since everybody else is being affected by the same thing, I'm not going to run, people. He says that he will provide escape in his own due time. I trust him. I honestly, with all of my heart, have faith. With that being said, I want to thank you guys for the opportunity of talking to you about the unauthorized practice of law. And if they can do it, you can do it. So if they want to charge you with unauthorized practice of law and say that there's a possibility that you practice law unauthorizably, then you sit up there and you go ahead and you charge them with unauthorized practice of law. You bring that up in your case. The moment they say, well, they have the right to do this, excuse me? They work for a private corporation. How in the world could they have the right to represent the state? Okay? That's all you got to do. These guys are all jokes. And again, don't use these case laws the way they're wording them, people. If you're going to quote it, don't use the double quotation mark, because this means that it's an exact quote from the case. Schwer did not say this. The practice of law cannot be licensed by any state. Schwer did not say that. You did not, when I did practice of law and we went through each practice of law, you did not see cannot be licensed by any state. It did not say that, did it? It's okay to practice God's law without a license. Excuse me, and they put the scriptures in here. Ladies and gentlemen, it is not okay to practice God's law without a license. Only the priest could practice that law. Or did you not know? Go back and look at the book of Ezra. Go back and look at the book of Leviticus, Levites. Those were the priests, people. Again, out the side of their neck, people talk. But anyway, what I would strongly suggest, ladies and gentlemen, if you're going to go to sites like this, don't just copy and paste the case law. Verify the information. Now, remember, I told you when I looked at this document that I would confirm the information if they had cases like the Brotherhood of the Trainmen, NAACP, and then I told you how I knew about Hines versus Kerner, excuse me. All right, I told you how I knew about this stuff. Now, and again, the respondent in this action is a non-lawyer and is moving forward in propria persona. Okay, as a poor person. Anyway, ladies and gentlemen, do your research. Don't just take this stuff lightly. You're in their arena. You are in their arena. You cannot go into their arena without being, pay attention, prepared. They will eat you up. This is the Roman games. Don't you understand? Where they fought against live, ravenous animals. Do your homework. All right. I hope this information proves to be of some benefit to some of you. If not, hey, we'll keep trying. All right. Have a good day, everyone. Have a good night. Have a good life. Have a good time. Have a good night.